Hello, everyone. This is Tom Fox. I'm the Compliance Evangelist, and I'd like to welcome you to episode 9 of Everything Compliance, the top roundtable podcast in compliance, where 4 of the top compliance practitioners and commentators get together to talk about everything compliance. This is part 2 of a 2-part episode on the recently released Department of Justice Evaluation of Corporate Compliance Programs document. In this episode, we have Jay Rosen reporting live from the ABA White Collar Conference, and Jonathan Armstrong, our colleague from the Quarterly firm in the United Kingdom. They follow the discussion we had last week with Mike Volkov and Matt Kelly. For everyone's written commentary on the evaluation, I've linked to their blog post and commentary on the show notes, so you have a opportunity to check out more in-depth writing on the subject. This is Tom Fox. Thank you very much for listening to this episode of Everything Compliance. Jonathan Armstrong, coming to us from the United Kingdom. Jonathan, did you have any initial impressions when you read the evaluation of corporate compliance programs, really one way or the other?
Yeah, I think it's an interesting document, to be honest. It's, I think, a kissing cousin of the Ministry of Justice guidelines that we had when we updated our Bribery Act. There was the MOJ, as you know, is not the same as the DoJ in terms of its role, but I think the documents are quite similar and the thinking is quite similar. I don't think that's a coincidence, because the US authorities helped the UK authorities put the Section 7 guidance in place. But most of the things, I think, carry across. I've been doing myself a little table, and there are a few gaps. The most significant, perhaps, is the concentration on middle management. The UK guidance is very much sort of top-down, tone from the top, and it misses out the mood from the middle, as it's known, which seems to be a feature of the US guidance and isn't really there in the UK guidance. And that might be a sign of how we've moved on since 6 or 7 years ago, when the first draft of the MOJ guidance came out.
So with that, Jonathan, what I thought I might do is really explore, if in some detail, the evaluation and see if you thought any of the things that the Department of Justice was now asking or even suggesting might negatively impact a compliance practitioner in the EU or the United Kingdom, or if you really think that they're consistent. So really, if you look at prong number 1, entitled Analysis and Remediation of Underlying Misconduct, the first one is a root cause analysis. And that is something that is new, was not in the 2012 DOJ and SEC guidance, has really not been talked about. Anyone who has been in a corporation or an industry is certainly familiar with that term of root cause analysis. But is there anything there that strikes you as might cause a compliance practitioner in your part of the world grief, or is that something that is really done on a routine basis?
I think the challenges there are, and we've talked about this before, Tom, the rise of data protection and privacy law in Europe. So we have to always be very careful when we scope this type of analysis exercise, because those in the EU have data protection rights, and they will change in May 2018. Now, in some respects, the situation's got a little easier, perhaps, by France, for example, introducing Sapin-2 and having local law requirements to do this type of analysis. But there's something new called the General Data Protection Regulation, which comes into force in just over 440 days' time in May next year, which I think does change the game from a data protection point of view. One of the rights that GDPR introduces is something called the right to be forgotten. That was before the European Court again last week. The judge made law. But the consequences, I think, are that individuals who are being investigated could ask that the data on them is forgotten. We've already seen that in a Russian case, the Goryev and Goryeva case, which is before or has been before the UK High Court. And to give you an example of the difficulty of the decision-making process here, I just did a little bit of analysis on the Rolls-Royce case. Now, I'm using some figures that I've just obtained from the internet, which might not be the most accurate, but we know that the Serious Fraud Office fine for Rolls-Royce's misconduct from a bribery point of view was 497 million sterling. The potential fine for Rolls-Royce in May 2018 for getting the investigation wrong from a data protection point of view would be 549 million. So whilst we might think that the 497 figure is staggering in itself, you could get a situation where a corporation faces a higher fine for conducting the investigation wrongly than it does for the conduct that it is investigating. So I guess Rolls-Royce's decision almost whether they, if you like, walked over the privacy rights of the individuals to get to the SFO in time, I guess that decision was quite easy last year. I think it becomes a more complex decision in 2018 because the higher fines potentially could be for data protection missteps rather than the original bribery.
That is pretty astounding. Any thoughts on whether that type of analysis could be used against a United States domicile corporation yet with operations in either the United Kingdom or in an EU country?
I think it could, yes. And as you know, the decision isn't as stark as that, because obviously the fines could be unlimited for bribery, et cetera, et cetera. But I think it is a difficult decision for US corporations. US corporations will be directly within the reach of GDPR, even if they employ individuals or they target individuals in Europe. So you don't even need to have a subsidiary company in the EU to come under GDPR. And you could get a situation, I think, where a corporation investigates, does a deal with the US authorities to settle the bribery, and then has a subsequent investigation from the EU authorities for the way in which it's handled data. And I think because of the way in which deals are, elements of the deals become public, that would be hard to defend any prosecution like that. And we're already seeing the level of fines go up in Europe. Yesterday, for example, the Italian authorities fined a number of companies 11 million euros for their part in a scheme allegedly to bypass foreign exchange control rules into China. So we're already seeing this tie-up of data privacy and other elements of bad conduct investigation.
So, Jonathan, you mentioned the sort of difference in the mood in the middle and the tone from the top. But turning to prong two, it's got three separate inquiries. One, it looks at certainly top leadership. Second, it begins to look at the operationalization of compliance through the shared commitment of other senior leaders and stakeholders, and even asks some questions about the board. And I was just wondering, is there a difference in the UK either corporate structure or really even corporate culture that would not allow senior leadership to have its compliance conduct or compliance tone monitored? Is that something that a UK company could reasonably well do within the culture of UK corporations?
I think there's certainly a need to address compliance in UK boards, and that's been recognised for some time. We've had various reports like the Cadbury report, which looked at how boards operate and the level of independence, et cetera, et cetera. And I'd hesitate to say it's better than the US. But I think most UK public entities are aware of the fact that, for example, the CEO's role and the chairman's role needs to be split. And it's relatively rare that we have a CEO who transitions into chairing the board, whereas my impression is it is more common for a CEO to chair the board in US corporations. We are driven, I think, in the UK certainly, on having non-exec directors and having them independent. And usually they will take the lead on compliance matters. Again, I see that from most of the US corporates I deal with as well, that if there is an incident, it's quite often, the chair of the audit committee or the senior non-exec director who takes the lead on that. So in some respects, I think there are some similarities, and I think there is an awareness that boards need to increase the compliance specialists on the board as well. And I think we're seeing my personal observation is that I think we've seen a diversification of boards of UK public companies in the last 10 years. And I mean that, truly in terms of gender, but also in terms of skills and backgrounds. I think that our largest public corporations aren't as black and white as they used to be in terms of who sits on the board and whether they knew each other and went to school with each other before. And I think that in itself increases the compliance quality, if you like, of the boards in the UK. Now, I'd like to say this was a completely voluntary process. I think actually a lot of it is pressure from shareholders, particularly some of the larger pension funds who've taken a good look at corporate governance and have suggested, or in some cases dictated, to companies that they have to improve. And there are still one or two that you could name that aren't as transparent as they might be in terms of how they appoint.
So under prong 3, there are some questions relating directly to the compliance function and the chief compliance officer. And it drills down into the level of titles, salary, rank within the corporation. Do you have a sense of the chief compliance officer or the chief compliance function having the kind of status in the United Kingdom or the EU that it would in a U.S. company, or is that something that is really still evolving in your part of the world?
I would say, as a gut reaction, this is something that the US usually does better. I think in the UK and certainly in other European countries, compliance tends to be Cinderella rather than the ugly sister, and pre-transformation Cinderella as well. So the compliance team are often relatively low in the hierarchy. Commonly, it tends to be somebody who is doing that, I think, as their last role within the corporation, but not from a more senior role. And the same is true of legal teams as well. I think it's if I just look at our client base, I think more of our US clients have a seat at the board than those of our non-US clients. And sometimes still legal is at least a step away and compliance a step underneath. So, for example, I can think of one client where legal reports through finance and compliance reports to legal. I don't think that's the right structure, and I don't think that would be defensible really under these new guidelines.
So in the U.S., we would say that role is filled by someone who used to be a coach. So coach would go first in the sort of 70s and 80s when you put a coach out to pasture. He went to personnel. That later became a little more professional with human relations. And so then coach went to compliance. So I certainly understand the compliance function being the corporate office of last resort, or not last resort, but of last sitting before you rotate out into the great beyond.
Yeah. Right.
In
And sometimes, of course, that's a good thing, because some of these people can know where all the skeletons are buried,
right,
and have good internal networks, and also not be too concerned about advancement at the end of the role. But in many cases, I've seen it somebody who's ready to be put out to pasture.
So prong 4 really gets down to some fairly specific requirements around the operationalization. And I'd like to ask you really around prong 4B, which is entitled Operational Integration. It's got a series of questions around integration, internal controls, detailing down into payment systems, and certification and approval processes. In the United States, we would see many of these as really just standard corporate functions that you would have to have, certainly in terms of internal controls. Obviously, payroll is one that every corporation should have, and that these controls would be probably designed by the functional units that use them, whether that be finance, whether it be accounts payable, whether it be another corporate function. Do you think that this really key operational section would translate over, even if it was called something different in the United Kingdom or the EU, or is this really would require an evolution as well?
I think, again, there's a mix. I mean, if you look at different corporations, I think they have different attitudes to these type of controls. And usually their attitude changes after they've had an episode, whether that's a public episode or a near miss. So if you look at Siemens, for example, obviously they had various controls and systems in place. It was, as I understand it, relatively easy to get petty cash before their incidents, and as I understand it, very difficult to get cash afterwards. So I think for most organizations, absent some sort of audit or their auditors getting interested in this as an area of activity, and I think that's increasing, they're not really proactively looking at these issues. They're certainly reactively looking at them if they have an episode, particularly when they know they're going to have to speak to a regulator and they're wanting to prove that they now have adequate procedures in place to stop that sort of thing happening again. So I would certainly be filing this under work in progress, I think, for Europe.
So you visited with us, the Everything Compliance Group, with myself on the FCPA Compliance Report podcast rather extensively on data protection and how that would impact investigations. But do you see those same concerns moving into the risk assessment area, or is that because is that a different enough inquiry that data protection and data privacy really would not impact as in talked about in prong 5?
I think it does still impact. I mean, I think it does impact the risk assessment. And in some respects, it can be more challenging to look at these type of issues from a data privacy point of view before there's an incident. Because as a general rule, data protection law can allow you to do certain things if there's, a bad thing has happened. But you have less leeway if you're trying to make some sort of a general inquiry into the state of the corporation or its suppliers or whatever. So I think that, it does impact throughout the planning and risk analysis that you're doing, and obviously impacts areas like due diligence as well, which are a focus here in prong 11, to look at pre-acquisition due diligence. Again, that can be challenging from a data privacy point of view as well, because you probably don't have the consent of the employees in the business you're acquiring.
Jonathan, in prong 6, it discusses compliance training. And although this is not new, this is probably as cutting edge as something in the United States as there is in the entire evaluation, and that's in terms of assessing compliance, training effectiveness, measuring effectiveness, and having tailored training, not just for based upon high risk, low risk, or medium risk, but really tailored to the business or the operation of the individual who's receiving the compliance training. Are these things that the UK is also evolving with, or would you say this would be a problem for UK companies?
No, I think the US and the UK are more or less on the same page with this, I would think. I've had discussions with people at the Serious Fraud Office about, the efficacy of training and how tailored it is, et cetera, et cetera. And I think that there's been some joint work between the US and the UK, looking, for example, at how effective standard online training packages are, i.e., not very, certainly in terms of high-risk employees. So I think there is a recognition that training to be effective does need to be risk-based. I think there is a recognition that the form needs to follow that analysis. So I've been involved, for example, in one-on-one training of an agent that my client was engaging to do something that's high risk. Obviously, they did due diligence on him. He comes across as somebody who it is perfectly proper to do business with, but they just thought the extra reassurance of having somebody sit down with him and give him a proper session, one-on-one, face-to-face, was an investment worth making. And I think that's right. I think an off-the-shelf package would be an expensive way of training somebody like that, and also not as effective of sitting him down and looking at the whites of his eyes. And equally, I think this sort of concept of multi-touch, which I agree isn't new. The Morgan Stanley declination, for example, had elements of that. But I think to train people properly not to do bad things, that does require frequent touch, and particularly, I think there's allegedly an age thing at play as well. That I think that whilst those of our age, Tom, might learn effectively through a 1 hour session, then I think at least the perceived wisdom is that our younger employees might want, to be told 10 6-minute things rather than one 1 hour thing. So I think attention spans can be shorter. And part of the mix will be, as it suggests here, looking at all sorts of different ways of giving guidance. So it might be quick fact sheets, it might be short films, it might be face-to-face sessions, it might be cascade learning. And I think all of that has to be risk-based. So different people in the business will be taught different things at different times.
And Jonathan, I'd like to end by focusing on prong 8, because this is really, I think, a key metric on the operationalization of compliance. And it's really directly focuses on HR, human resources. And would a UK company be comfortable having the HR department involved in discipline if required for someone who has violated a code of conduct, engaged in unethical behavior that violated a company policy or procedure, or indeed violated the FCPA or the UK Bribery Act?
I think this is a very challenging discussion, and it is a discussion that we're having over here, and we're also having that in other parts of mainland Europe as well. For example, as you might know, in France, a whistleblower helpline complaint should not go to HR because the French want there to be a separation of the investigatory team and the HR team. And their rationale is if the investigatory team decide that there is no case to answer, then that information is still contained, and the suspect isn't prejudiced in their life with the organization. At the same time, we've had some at the SFO believe that HR professionals should be more involved in conducting internal investigations. And the rationale for that seems to be so that privilege isn't an argument, because HR's leading the investigation, not legal. And so that would allow the SFO unfettered rights to access all of the documents from the initial investigation without somebody saying that this bit or that bit was privileged. Whether that's in the public interest, I am not sure. We go back to this case called Dardala, for example, that where the prosecution failed, and we're not exactly sure why, but it seems to me that following the right process and procedure is in everybody's best interest, really, to give the victim a chance for their worries to be heard, to give the suspect a chance to defend him or herself, and to enable the investigation to get at the truth in an impartial manner. So from a personal point of view, I think HR can be useful in supporting the investigation, but I wouldn't want to see them lead it. I think HR has other bits of good compliance that they do have to lead, however. First of all, due diligence on new hires. I don't see enough of that, and particularly in key areas that can be critical. We don't take up references on employees. Why don't we when they're being recruited into critical areas? And secondly, on remuneration as well. I think there is obviously a flavour throughout this document that we have to make sure that people are paid for good behaviour, not bad. And again, I'd like to see HR teams take the lead on that as well and look at proper ways of recompensing people that don't reward bad behaviour.
Well, Jonathan, thank you. Let's turn to Mr. Affiliated Monitors himself, Jay Rosen. Jay, welcome.
Thanks, Tom. I'm coming to you from Miami Beach, the Fontainebleau Hotel, which is the setting for this year's ABA White Collar Crime Conference. And first of all, I'll just pick up with that note that Matt made, that yesterday's ZTE settlement, everyone seems to be breathing a bit easier here, and it feels that the DoJ has at least put one run on the board for law and order. So I think, as Matt said, we really are still in the business of prosecuting. And the key point from ZTE that I wanted to take out is they not only violated export controls that keep sensitive American technology out of hands of hostile regimes like Iran's, but they lied to federal investigators and deceived their own counsel and internal investigators about these acts. And this is a quote from Attorney General Sessions. This plea agreement holds them accountable and makes clear that our government will use every tool we have to punish companies who would violate our laws, obstruct justice, and jeopardize our national security. So I think, this really emphasizes the link that many of us have been making for the past few years, that, not only do we need to enforce the FCPA because it's right and it's just, but a lot of these ill-gotten gains sometimes find their way to terrorist organizations. So really, yesterday's ZTE settlement does not really deviate far from what the Trump administration has been saying about providing security and protecting our borders. So I thought that was great. In terms of what people, here at the conference have been saying, and, what kind of vendor interaction we're having with people, this enhanced guidance starts with this note that says, we recognize that each company's risk profile and solutions to reduce its risks warrant particularized valuation. Accordingly, we make an individual determination on each case. So while these are, suggested questions to ask, although it's not a duty to do so, many people have said here that this really is the game plan. And if you're called into the DOJ, or if you're reporting and you're in the middle of a matter, it would be quite reckless and foolish to disregard any of these questions. And you should at least have answers for them because they're going to be asked. I think chiefly this talks about, if you have a problem, how do you go about diagnosing it and what do you do? And the guidance asks these questions: what does management do? Does management have resources available to remediate? And what policies and procedures are in place to correct the issues? And I kind of think the guidance falls into 4 separate areas. The first one is, doing the analysis when Matt talked about doing that root cause analysis. So first of all, it speaks to what is the problem that you found? How can you correct it? The next section talks about preventative measures, where we look at risk assessments, training and communication, confidential reporting, and incentives and disciplinary measures. And topics 9 through 11 speak to how do you weave the ethics and compliance into your business moving forward. And I know this is a subject that's near and dear to your heart, and you're often talking about how do you operationalize compliance into day-to-day. And the last point that really sticks out here at the conference is taking a look at how you handle your M&A process, and specifically drills down to due diligence. How has compliance been integrated into M&A in this process? And finally, the process of implementing compliance when you bring the new entity on. So a lot of the chief compliance officers and fellow practitioners that I've kind of connected with this week, this conversation seemed to keep coming back to the evaluation of corporate compliance programs document, and feeling that there can no longer be any excuses of not knowing. This guidance takes the step of further codifying the government's expectations of what a reasonable compliance program should look like and how it should be presented and implemented. In terms of how this changes the conversation, here at the conference, the guidance is somewhat preaching to the choir. Once we drill down into the conversation with companies' in-house counsel, as well as members of the white-collar bar, the conversation is not about if you do this, but moves directly to when, and that when needs to be now. So frequent issues that kept coming up about due diligence, specifically within M&A transactions. And in a merger, there seems to be such momentum from the M&A attorneys and bankers driving the deal that they want to get to the finish line. And quite often, key due diligence of culture, of having a robust ethics and compliance program, and even looking at third-party due diligence seem to be mere afterthoughts, or more often left on the side of the road. So taken as a whole, these requirements for ongoing monitoring, risk assessments, root cause analysis, and the need for companies to explain how something might have fallen through the cracks all argue for enhanced ethics and compliance program. And I guess I'll date myself a little bit, but it reminds me of this old Amco commercial that they used to have, and used to say, you can pay me now or you can pay me later. And from an independent compliance monitor perspective, we would rather help our clients implement a robust ethics and compliance self-assessment to keep them on the right path and avoid having a situation where they stumble and a settlement is negotiated, thus necessitating a multi-year monitor agreement. So those are my kind of initial thoughts on it from Miami Beach.
Well, Jay, how would you suggest a chief compliance officer or a compliance practitioner even begin to think through testing their system? Obviously, the evaluation talks about a root cause analysis. It talks about a risk assessment. But as we both know, there are multiple components to a best practices compliance program. You mentioned specifically M&A. I talked about third parties, but of course there's policies and procedures, there are internal controls, there's training, there's discipline and incentives. Any thoughts on maybe how a chief compliance officer could think through it? Or is the basic message here that I cannot do this alone? I really have to have the help of the other functional disciplines within a corporate organization?
I think the latter makes sense. The CCO can have a template on how you make it work, but I think one of the key things that you need to have is you really need that independent perspective, that eye in the sky. And just as we often find problems because things were internally handled or monitored, or the box was checked off, if you really have some type of overview from other departments or even going to an outside vendor, I think that keeps you not only current with a fresh set of eyes looking at things, but it also may help you potentially find pitfalls that you may not have seen because we tend to be a bit myopic within our own organizations.
And then within, you did mention that, of course, down at that conference, in many ways it's preaching to the choir. But how any thoughts or communications or even cocktail chatter on how the CCO or the compliance function can start to have those discussions, or is it simply a matter of this is what the Department of Justice says we need to talk about? Let's have a conversation.
Yeah, I think the last one really signifies it. And you know how there used to be that kid in the class who'd sit in the front row? Not me. I'd like to sit in the back. But they would consistently raise their hand and say, is this going to be on the test? Well, we now know all the questions for the test. So if we're not preparing for them, shame on us. So everyone just really sees this as very helpful. And I think the reception that, that the pundits and the marketplace have for this is when that initial guidance came out a couple of years back, everybody said, well, this isn't anything new. This is just a compendium of things that are out there. But I think there is a certain freshness to this. And it's really the questions that you want to ask in a self-examination. And I'm not sure if Matt said this earlier or Mike, but they're not telling you what to do, but they're telling you where to look. And I think this is the list that people have been waiting for. And, I think we should start to see, this helping towards resolutions and what's going to be happening in the coming year.
Well, gentlemen, this has been just a fabulous discussion about the evaluation of corporate compliance programs. For all our listeners, I will link to everyone's postings on this and ZTE, as that seemed to be something that really ties into today's topic. So with that, I'm going to wish everyone adieu, and we will look forward to visiting with you all again. This is Tom Fox. Thank you for listening to this episode of Everything Compliance. If you'd like to pose some questions to our panel of expert commentators, you can shoot me an email at tfox@tfoxlaw.com. If you have listened to this podcast on iTunes, I would greatly appreciate it if you would rate us, as it would help our rankings and also help us to get the word out about top roundtable podcast in compliance. This is Tom Fox. Thank you very much for listening to this episode of Everything Compliance.